Hi there, welcome to the program. Hope you're enjoying your day so far. Cloudy day ahead today, going down to -2 tonight, and we got some snow coming up later on in the week, and then some heavy rain in time for the weekend. So hold on to your hat. Quite literally, we like to begin this program by pointing out who is sorry, who has been shoving some shoe leather down their throat, who's got a mea culpa. Every day in the news, there is someone who is sorry now. All right, so who is sorry now? Nipissing University has issued an apology for a, quote, hurtful and inappropriate comment made during the Lakers women's basketball game over the weekend. Now, the Nipissing Lakers are the athletic teams that represent Nipissing University in North Bay, Ontario. There was a comment made by the announcer who has not been publicly identified, although, if you were watching the thing, you know who it was. The comment by the announcer was, quote, nice stroke for a girl, unquote, as a Laker player made a basket in a game against Queen's University. I'm going to call a foul on that. I think that is definitely a foul. A Nipissing, said the announcer who made the comment, has apologized and, quote, will no longer announce for the Nipissing Lakers. And ladies and gentlemen, that is sorry now. There's always somebody sorry. I got time for a quick sick burn. You got time for a quick sick burn? This comes from the legislature, from the Ontario legislature at Queen's Park today. Mike Schreiner, the leader of the Ontario Greens, was questioning the Premier about this recent report about climate change and how dire the situation is for the world. And then Mike Schreiner brings out the sick burn.
Speaker, the climate fires are raging all around us. It is obvious, and the Premier has brought a little red shovel to fight them instead of a big fire hose.
Is that a little red shovel in your pocket, or are you just the mileage that critics are still getting out of the little red shovel? Of course, you remember that when we had the big snowstorm back in January, Doug Ford was out there with his little red shovel digging people out. That's your sick burn from today from Queen's Park and Question Period. But let's get to it, shall we?
Our top story.
All right, we're going to start our top story with a tricky situation, especially for those of you out there who are divorced. Where are my divorced dads, my separated moms? Where are you at out there? You've been having some difficulty with your ex over trying to navigate the pandemic when it comes to the kids. Well, check this out. A Hamilton family court judge has ruled in favor of a mother who doesn't want two of her kids to be vaccinated against COVID. Now, the case involves a mother, CG. We only use initials in this situation. CG, 34. Father is JN, who's 35. They married in 2007, separated in 2014. They got 3 kids. They got a 14-year-old son who lives with dad, a 12-year-old daughter, and a 10-year-old son. The young two reside primarily with mom. The Ontario Superior Court Justice Alex Pazzatarats, found that the vaccine's potential side effects actually justified mom's caution. The judge cited a long list of rights abuses to explain why courts should not simply defer to government experts. Quote, what about the residential school system? For decades, the government assured us they were taking Indigenous children away, and being willfully blind to their abuse was the right thing to do. We're still finding children's bodies. That's a quote from the justice, who added in a postscript that he personally is vaccinated. But all of this reflects a debate among judges and in the legal community about the role of assessing facts surrounding vaccination, especially when you come with disputes with parents. It's fascinating stuff. And to help me understand it better is Laura Paris, who's a family lawyer at Shulman Partners. Welcome to the program. What's your takeaway from this ruling from this Hamilton judge?
Honestly, I think that this is a great decision, and I think it's a decision that we've been waiting for. I mean, we need to appreciate that with unprecedented times comes very, very difficult decisions. And the family court is often a breeding ground for petty disputes, unfortunately. And with the onset of COVID, more disputes came up, and judges had been tasked with dealing with these, again, very difficult issues that are coming from unprecedented times. And what the pattern that we've been seeing with decisions that have been coming out as it relates to the vaccine is that a lot of judges have been taking, what we refer to as judicial notice of government protocols, and essentially, almost undermining the role of evidence in making decisions, and the tests and the rules that we are guided by in making decisions. And I think what this judge has done very correctly is reminded us what a judge should be considering when making these decisions, and simply following the guidelines of the government, whether you agree with them or disagree with them, is not necessarily the end all be all in determining what the appropriate decision is on an issue like vaccines.
Does the law side on the mothers because the children primarily reside with her? Is that the basis for the ruling?
So there's a couple of things, but I would say the main two reasons why this decision or three reasons actually why this decision went in the mother's favor, is when you're considering decisions that are decisions relating to children. What we're primarily guided by is what is in the children's best interest, and there's a certain set of criteria that we look at in determining what is in a child's best interest. Part of that is what the children's independent views and preferences are, and in this particular circumstance, the children did express, and their views were independently ascertained, that they did not want to take this vaccine. Another piece of information that the court looked at is the history of parenting, and the ability of the mother to be a good parent. And what was noted was that these parents were able to negotiate a separation agreement and agree that both parents had sole decision-making authority over the children that were living under their roof. What the judge inferred from that decision was that both parties agreed that the parents were capable of making appropriate and informed decisions for the children. Therefore, it was not just as a result of the mother's hesitancy towards vaccines that didn't paint her in a light that she was incapable of making a decision that was in the children's best interest. The third point is the evidence that was put forward, where dad relied simply on public health guidelines, and really used this motion and this issue as a means of smearing the mother, smearing her with respect to her political views, with respect to certain Facebook posts, things like that. The mother actually was very well researched in her objections, provided very what the judge considered to be reliable evidence to demonstrate why she had hesitancy towards the vaccine. So with all of that evidence taken into account and the best interest of the children, the judge came to what I believe is the appropriate and correct decision, that those two children not be vaccinated.
And is the basis here then, again, because, you point out that there is, the court ordered a social worker to interview the kids, and that social worker said it appeared that the children expressed the wish not to be vaccinated and they had not been manipulated. But I find that, as a divorced dad myself, it sometimes gets into disputes, and I'm very fortunate, we see eye to eye, the parents, the kid's mom and myself. But that is difficult to ascertain. How possibly could you do that?
I do agree with you that it is difficult to ascertain. I mean, we use the resources that are available to us. We have professionals that we rely on to ascertains children's views and preferences, and when they are doing so, they are doing so in a manner that they have certain training to ask questions in a certain manner to try and determine whether or not there's been influence. Is this a perfect exercise? Of course not. Is there any sort of perfection that you can ever expect to get when you have third parties making decisions on matters that relate to your own children? I don't think so. And I think that really what what this case overall should remind us of is that the family court, while it's there as a last resort, the family court should not be used as a means of making decisions for you and your family, because ultimately I think that, we certainly have outlier situations, but for the most part I think parents are the best people to make the decisions for their families. So when you're asking a third party to come in, they do their best with the resources that are available, but there's absolutely no perfect way or absolute determination of whether or not there's been influence here.
Laura, great to talk to you. Thanks for your analysis today. That's Laura Paris, who's a family lawyer at Shulman and Partners. Now, when we come back, as you well know, the vax passports are gone as of today in the province of Ontario, but not everywhere. Some restaurants are saying, no, hold on, we're going to keep it in place. We'll tell you about a restaurant just like that. We're going to talk to food reporter Corey Mintz about it when we come back.